The Supreme Court just issued an emergency decision that could eliminate gun permits across America. And the Department of Justice isn't fighting it, they're backing it. 26 states have lined up on one side of this battle. Permit-heavy states are scrambling on the other. And what happens next will completely rewrite how every American exercises their Second Amendment rights. This is the biggest gun rights case since Bruen. And if you care about where this country is headed, hit subscribe right now because the fallout is already starting. To understand why this case exploded the way it did, you have to look at what Hawaii tried to pull after the Bruen ruling came down in 2022. The Supreme Court made it crystal clear that states couldn't hide behind may-issue permit systems anymore. Those days were done. But Hawaii looked at that decision and decided to build something even more restrictive. They created a system that completely inverted public carry in America. Under Hawaii's new rule, you could only carry on private property if the owner gave you explicit written permission ahead of time. No sign posted, you're automatically breaking the law, and Hawaii wasn't alone. California, New York, New Jersey, Maryland, Massachusetts. They all watched Bruen land, nodded politely, and then drafted laws designed to get around it. They didn't eliminate permits. They reinforced them. They didn't expand carry. They squeezed it tighter. Between 2022 and 2024, these 5 states passed 47 new firearm restrictions, with Hawaii leading at 14 separate laws. Hawaii's version crossed a line even the Ninth Circuit struggled to defend. Their law made 99.8% of private property off limits, unless you proved explicit permission. Gas stations, shopping malls, parking lots, all banned by default. This wasn't regulation. This was elimination. When lower courts upheld it anyway, the Supreme Court found themselves staring at a law that openly challenged their authority and created a circuit split that couldn't be ignored. Hawaii built their entire defense around a single historical analogy from the 1800s that had nothing to do with permits. But there's one thing that makes this case fundamentally different from every other Second Amendment battle, and it starts with who showed up to fight. The Department of Justice flipping sides in a gun rights case is almost unheard of. Usually, when a state builds a restrictive permit system, the DOJ defends it with arguments about public safety. But when Hawaii's law reached the Supreme Court, something extraordinary happened. The DOJ filed a brief essentially admitting Hawaii's system wasn't defensible under Bruen. They told the court outright that Hawaii's law wasn't about property rights. It was engineered to suffocate carry rights through a permission structure with no historical foundation. They pointed out that trespass laws already give property owners all the tools they need. So why create a default ban? Because the goal was restriction, not protection. The DOJ's brief used the word pretextual 4 times, legal language for calling someone a liar. Then came the shock. Tihi, DOJ, formally requested to participate in oral arguments on the side of the challengers. In the last 40 years, the federal government has switched sides in a Second Amendment case at the Supreme Court, exactly 3 times. This is number 3. When the country's top legal office steps in to help dismantle a state's permit structure, every courthouse in America pays attention. State attorneys general started calling each other. Legal defense funds reallocated resources. Everyone realized the battlefield had shifted. And just when permit-heavy states thought they'd seen the worst, 26 states joined the fight on the challenger side. Not 2, not 5, 26. That's more than half the country filing briefs arguing Hawaii's model represents an unconstitutional threat to national consistency. This wasn't backup. This was a legal show of force. You know what this means for states that built similar systems? But first, you need to understand exactly how Hawaii's permission trap actually worked on the ground. At the center of this battle sits one deceptively simple trick. Hawaii tried to rewrite permission itself. Instead of, you can carry unless a property owner says otherwise, Hawaii said, you can't carry unless someone grants explicit written approval. They turned the Second Amendment into a permission slip most property owners would never know they were supposed to issue. Think about how this plays out. You're a law-abiding gun owner. You completed Hawaii's permit process, paid fees, passed background checks, finished training, and received your state-issued permit. You walk into a grocery store. Is there a sign saying Firearms, welcome? Probably not. Under Hawaii's system, that absence meant you just committed a crime. The store owner didn't have to post no guns. They didn't have to say anything. Their silence became a legal trap, and Hawaii knew it. Internal legislative emails showed lawmakers specifically discussed how most businesses won't bother posting permission signs and how that would create a de facto carry ban. They said the quiet part out loud. The state's attorney general estimated fewer than 0.4% of businesses would post Firearms welcome signs. That's the intended result. This is the reverse, Bruen. Bruen made clear the right to carry is the default and restrictions need historical justification. Hawaii inverted it entirely. The ban became the default. Even the Ninth Circuit struggled to find historical analogies, citing exactly 2 examples from the 1860s that 3 other circuits rejected outright. Here's what should terrify anyone who cares about constitutional rights. If Hawaii can redefine the starting point of the Second Amendment, what stops states from doing the same to the First or Fourth Amendment? The Supreme Court is about to answer that. But the real battle isn't in Hawaii anymore. It's spreading to states that copied the playbook, and the chaos is already starting. This stopped being about Hawaii when the Supreme Court agreed to hear it. If they strike down Hawaii's model, the impact rolls across the country, knocking down every copycat state. California, New York, New Jersey, Maryland, Illinois, and Massachusetts built nearly identical structures, hoping courts wouldn't swat them down individually. If Hawaii loses, that shield disappears overnight. Here's what makes the timing explosive. Right now, 127 separate lawsuits challenging state carry restrictions sit in federal courts waiting for a signal. Not 12, not 50, 127. Lawyers have paused filings, judges delayed hearings. States have been buying time, hoping the Supreme Court wouldn't intervene. That bet is about to fail. Tis Tsaos. The moment a ruling lands, we're talking weeks, not months. Every one of those 127 cases wakes up simultaneously. Plaintiffs will file for immediate injunctions. States will scramble to rewrite statutes overnight. Courts will have to rule based on brand new precedent. Look at what's already happening before the ruling drops. New York quietly stopped enforcing 3 post-Bruen restrictions in January 2025, after internal memos warned defending them was legally untenable. California delayed 2 planned permit requirements indefinitely. New Jersey's Attorney General told prosecutors to exercise discretion on permit violations. Code for "don't enforce this because we'll lose." These aren't small adjustments. These are governments backing down because they see what's coming. The ruling will create a national standard every state must follow. What nobody's talking about publicly yet is the secondary wave. Once permit requirements fall, what happens to the massive industry built around them? That's not hypothetical. It's a financial earthquake about to hit state budgets and private contractors, and the numbers are staggering. Permit systems weren't just regulatory tools. They were revenue engines generating hundreds of millions annually. California collected $47.3 million in permit fees in fiscal 2023. New York brought in $38.6 million. Illinois collected $29.4 million. Across all permit-heavy states, that's over $200 million per year from application fees, renewals, training requirements, background check processing, and administrative search charges. That's just government revenue. The private sector around mandatory training dwarfs it. Industry estimates put required carry training courses at $680 million annually nationwide. This is a full ecosystem. Companies printing certificates, shooting ranges built for state-mandated courses, software firms selling applicant tracking systems. When permits become optional, that revenue evaporates. States are already feeling it. Hawaii's permit division employed 47 staff in 2023. By February 2025, that dropped to 19 because applications plummeted 78%. New York has refunded $6.8 million to 14,000 applicants for training courses courts blocked. California stopped collecting the $100 issuance fee in December 2024, losing $1.2 million monthly. The fiscal impact reports are brutal. New Jersey's Treasury estimated eliminating permits creates a $41 million budget hole they have no plan to fill. Illinois projected $33 million. These aren't abstract numbers. These are staff salaries, office leases, and IT systems that suddenly have no funding. The private training industry is in freefall. 3 of the largest carry training companies filed bankruptcy between November 2024 and February 2025, all citing anticipated regulatory changes eliminating mandatory training requirements. But if you think the financial chaos is bad, wait until you see what's happening to people enforcing these laws right now. Law enforcement is caught in an impossible position. The first shockwave hits sheriffs, police chiefs, and prosecutors trying to enforce laws that might be unconstitutional while a Supreme Court decision looms. In January 2025, 19 California sheriffs issued a joint statement declaring they'd no longer check carry permits during stops unless the individual was committing another crime. Their reasoning: we cannot, in good conscience, enforce a requirement the highest court may strike down within weeks. That's 19 elected officials publicly refusing to enforce state law. Not because they're anti-government, because they're protecting themselves from civil liability. They're not alone. A December 2024 survey of 340 police chiefs across 8 states found 62% issued internal directives telling officers to use discretion on permit violations. Translation: look the other way, unless there's compelling public safety reason. Prosecutors made similar calculations. Between June 2024 and January 2025, district attorneys in 14 counties dismissed 1,847 pending charges related solely to permit violations. Not charges involving prohibited persons, not charges tied to other crimes, just permit paperwork violations for law-abiding citizens. Why drop cases? Because if the Supreme Court rules against Hawaii, every conviction becomes a potential civil rights lawsuit. Defendants will sue for wrongful prosecution. They'll demand legal fees. Some will win substantial damages. No DA wants to write six-figure checks for prosecuting under an unconstitutional law. Gun control groups went into crisis mode. Every town held 3 emergency strategy calls in January 2025. Leaked communications show them discussing alternative regulatory frameworks and post-permit strategies, not the language of confidence. Gifford's Law Center redirected $4.2 million from state lobbying to federal litigation support. They're not fighting to win. They're fighting to limit how badly they lose. This isn't just a legal fight anymore. It's a fundamental question about how constitutional rights work. And the Supreme Court's answer will echo far beyond guns. The Supreme Court isn't just reviewing Hawaii's law, they're weighing whether the right to carry starts with you or with the government. If the answer is you, then every state that built policies around permission first, right second, loses its foundation. States argued for decades that gun rights are special, that requiring permission is reasonable in ways it wouldn't be for speech or religion. The Supreme Court rejected that in Bruen. They said the Second Amendment gets the same protection as the First or Fourth, but permit states didn't listen. They kept treating gun ownership as a privilege subject to government approval. Hawaii took it to its extreme. They built a system where you have no right to carry anywhere unless a random store owner grants permission. Imagine needing permission from a building owner before speaking freely inside their business, or needing written approval before refusing a search of your property. The historical test Bruen established makes this clearer. Legal historians found 0 examples of blanket permission requirements for carrying arms. States regulated where and how, but never required government permission to exercise the right. The closest analog was an 1870 Tennessee law requiring pistol permits. Tennessee's own Supreme Court struck it down in 1871 as unconstitutional. Hawaii tried arguing property rights, created an exception. True, owners can exclude armed people through trespass law, but that's different from requiring written permission before entering property open to the public. One system respects rights, the other eliminates them. This is the moment of truth. It's not just about carry laws. It's about deciding who holds default power, the citizen or the state. Once the Supreme Court answers that, everything else falls into place. But implementation won't be simple. It'll unfold state by state in ways nobody can fully predict yet. What does America look like if permits disappear? We already know. 29 states allow permitless carry right now. Between 2010 and 2024, 21 states transitioned from requiring permits. Crime didn't skyrocket. FBI data shows violent crime in constitutional carry states decreased 8.2% in the 3 years after implementation versus 2.1% in permit-required states. Vermont never required a permit. Not in 2024, not in 1924, not ever. Vermont ranks as one of America's safest states, with one of the lowest gun homicide rates. Maine adopted constitutional carry in 2015. 10 years later, their gun homicide rate is 1.1 per 100,000, lower than before the law. New Hampshire went permitless in 2017. South Dakota in 2019. Neither saw increases in gun violence. What permitless carry does is eliminate bureaucratic mazes for law-abiding people, while doing nothing to stop criminals who weren't getting permits anyway. Implementation varies. Some states went fully permitless. Others kept permits as optional for reciprocity. Training shifts from mandatory government requirements to voluntary private education, just like we don't require civics classes before voting. The Supreme Court ruling won't create one uniform system. It'll create a baseline states must meet while leaving room for variation. The practical rollout will unfold over 18 to 36 months as states update statutes, courts resolve cases, and law enforcement adapts. Some jurisdictions will move quickly because the legal writing is on the wall. Others will drag their feet until lawsuits force them. But the direction is clear. America is moving toward a system where the right to carry doesn't begin at a permit office, doesn't depend on bureaucratic approval, and doesn't require paying fees to exercise constitutional rights. It begins with the citizen. The Supreme Court is about to make that official. So that's where we stand, a Supreme Court ready to redefine gun rights, states scrambling to rewrite their laws, and a permit system running out of time. If you want to stay ahead of this story as it unfolds and understand exactly how it affects your state, hit that subscribe button and turn on notifications right now.